Simon and Michael, you were actually going to, I think in an earlier iteration of us talking about this session this morning, going to do a joint presentation on the GDPR itself. So I'm just going to ask you both to sort of do a mini version of that for, you know, a basic explainer of where it comes from, what it is. And Michael, I might drop you in at first.
Well, I'm going to maybe just shift to Simon because he's right in the middle of it. We are, Timothy and I are kind of outsiders to a certain extent. Yep. It's something that's clearly going to impact the world beyond Europe. But, and I should also say that thinking of my kids who, in terms of the dancing we were talking about this morning, Dad, don't embarrass yourself. And so there was never going to be any dancing. So Simon's brain is...
I'm flicking to the right flipping presentation now.
You can do it without your bloody presentation, can't you?
Well, I can tell you about the UK's approach without any bloody presentation, definitely. Okay, I'm fully immersed in that.
First of all, just give us a who, what, where, when. I mean, you know, for those who might not know in the room, what is it and why does it matter?
What is it? Well, apologies if there's a bit of personal perspective on this.
That's right.
It's some years ago now, in the dim and distant past, it was decided that we needed to bring data protection regulation into the 21st century in Europe. Yes, who coughed then?
Pipe down, you.
You didn't cough at the prospect of the strategy, the idea. Of course we do. Things have changed massively, and in the time since the GDPR was first mooted, they've changed even more. So this regulation was something that I've seen in gestation, and my ex-colleague, Deputy Commissioner David Smith, used to come to our management board and he used to give us the same answer when we said, when is the GDPR going to be made law? And he used to say, in about 3 years. Now that just carried on. He just said in about 3 years. And eventually it has come into and is it a perfect piece of legislation? Well, I'm sure that's something we might discuss later. As far as we're concerned, we see the GDPR as sort of evolution from the law that's applied in the UK. Yep. It's different from some other EU member states. So I was lucky enough to attend an APA meeting in Mexico last year, and we had a presentation from the French Data Protection Authority. And it's a big change for them because their approach is very much the box-ticking approach. The UK has not ticked a box for as long as I can remember. And so for us, it's more evolution, not resolution. Our law is principles-based. It's around fair processing. It's around not keeping data for too long. The GDPR is. It's about rights for individuals, but responsibilities for organisations. And the ITO will continue to be the regulator for the UK. The big difference is, well, I suppose there's greater emphasis on control and the rights of data subjects. Well, who would disagree with that? Where you might have some challenges as organisations is how far that goes. It clarifies the definition of personal data. It makes consent more specific.
Yep.
It's supposed to engender transparency and accountability and places obligations on data controllers and data processors, additional responsibilities too. Organisations need to appoint a data protection officer. There are fines, big fines, massive fines.
How big?
4% of global turnover. What's that for Facebook? Anybody?
Depends. GDP of Australia, I think.
Depends on the year. And it's sources of advice and guidance. I mentioned a couple of things this morning that are now going to be compulsory as opposed to optional, some things like privacy impact assessments. Yep. It also makes the data breach notification compulsory. We've got it in the UK now, but it's voluntary, and it will be compulsory, and that's a big deal across Europe. For some countries it is now. So that's the sort of thing it does. But the other thing that's of interest, I think, to people in the room here is it doesn't just stop in Europe. There is potential for it to affect organisations who are based anywhere in the world but have main establishments in Europe, or indeed deliver goods and services in Europe.
So tell us how. Give us just a couple of examples, I guess, maybe the most obvious and then a more obscure. I mean, you know, how distant and separate an organisation from the EU could be affected by this? I mean, if you shipped any good or product into...
Yeah, well, I'll give you the classic example is a multinational firm who is headquartered in Australia, but has a big presence in Europe and has a big, a tower block full of people working for them in a great city like Entwisle, say. Sorry, there's no one in Entwisle.
But then how does that differ from that company having obligations under any set of legislation if they're operating out of that country?
Maybe I'll just step in there for a moment. So I think that's the difference between what the old directive was and what the regulation is now. So under the old directive, it was if you were based in the EU, a foreign company, clearly it applied to you. Now it doesn't matter. If you are dealing with the data of a European citizen and you're in Australia or British Columbia in Canada, you're providing goods or services in that respect, or you're, I think, tracking, monitoring the behavior of European citizens, you're captured in the sense that the law in the EU will apply to your business in Australia, even though you don't physically reside there.
Oh, so it won't just apply to your entire business here in Australia, not just...
It could be if you're in... Yes. And so what the EU, and this is, I think, still being sketched out now, how this would actually work, they would look for evidence, do you provide the goods to European citizens? Do you have things in euros or in pounds and so forth? That kind of evidence they would look to see whether or not the law would apply to the business in Australia.
Is this office going to have the ability to actually investigate all of that and investigate all these breaches all the way around the world?
Well, yes. For the big companies with a main base there, that's relatively straightforward. But the example at the other end of the scale, the company that simply provides goods and services, that's going to be more challenging because who is going to be investigated and how will that investigation take place? Those are big challenges. I just want to mention one other little point. The quid pro quo, anyone in Europe is covered, and it's not just citizens. I had this pointed out to me by the French Data Protection Authority. So if you're in Europe and you're the subject of some heinous data protection issue, then you are covered by the GDPR, so you can be reassured on that point.
Which is in the same way that European citizens are able to complain to me for a breach as well.
Similarly in Canada.
It's a shortish session that we've got now before we break for lunch at 12:45, so I'd encourage you to get in early, if not right now, with your observations and questions. Do we have any, just to begin with? I mean, we've immediately got sort of a big issue here in terms of an Australian company or organisation's exposure and requirements to and under this legislation simply by dint of the work you might be doing. There's a hand raised there. I'll go to you first. Then I've got some questions to get through as well. Any other questions over the side of the room? Am I missing anyone? No? Okay. So go right ahead.
Yep, hi. I just
nice and high.
Better?
Yep.
Just had a quick question in regards to the conversation we were having around whether an organization is actually located in the EU or not, and how that relates to having a data protection officer. So, if you are selling goods and services to the EU, but you're actually only located in Australia, how does the DPO process work, or what is expected?
Who would like to try and answer that?
Well, I think that if you're just providing goods and services, you will be essentially doing a good job, we'll hope, and complying with Australian law. And I don't think there will be any requirement for you to appoint a separate data protection officer and go beyond what's required in Australia.
The challenge for Australian companies, as most of you will know here, is that the Australian law doesn't require by law there to be a privacy contact officer or a data protection officer. That's one thing I've picked up in the code for Commonwealth agencies that there will be, but at the moment there's no legal requirement for that. So it's an area that we have in question about how that will impact.
So why don't you just speak to us briefly then, Timothy, about, as you understand it so far and the form that it's taking, the specific consequence for Australia and Australians?
Well, I think the main consequence, and we've put out some guidance already on our website for Australian companies, which has been actually exposed through the Article 29 working group, and I understand got some positive feedback. So that guidance is quite good, from my opinion, and others' opinion, which will give you the key head issues that you need to start thinking of if you are dealing or trading in Europe, things that you need to consider, and also the things that are already covered by our Privacy Act in Australia that you should be doing. So things around having a good governance process in place, undertaking privacy impact assessments, those sort of things are already covered in our law and by our Act, and they're things that will be required by the GDPR. But we also run through some areas that aren't covered, and that is things like the mandatory requirement for privacy contact officer, and they're still questions we're looking forward to getting answers to so that we can advise Australian businesses. It also goes to areas such, and I'm pleased to say we've changed our law now, so there is a requirement in the GDPR for a mandatory data breach notification scheme. Yep. As I said earlier, that comes into force here next February. So what we've done is we've done a table that shows some of the key requirements of the GDPR and where we think the Australian law already meets it.
There are some key similarities. If you just mentioned one there, that the mandatory data breach notification, but the Australian requirements aren't quite as onerous as the EU one. Would you say that?
Well, I'm not quite sure I go down the path of saying they're not quite as onerous. There are going to be differences and there are going to be gaps, and that's what we have to work through. But there's going to be a lot more similarities, I think, than differences, and that's what we need to draw on. But that's where we need to get, as the regulator and as well as businesses, more information from the Article 29 committee about what is going to be the expectation, particularly around this vexed question of pursuing an Australian company for a breach in Europe.
Yeah, and we'll get to that in a moment. But Michael, why don't you give us the BC perspective on that?
Well, BC, Canada, and even beyond Canada, I think there is similarity in terms of the framework. It's consent-based legislation, essentially. But what the GDPR has done, I think, is really up the game. It's given individual citizens greater rights in terms of consent, the provisions which are strengthened, mandatory breach notification, which doesn't exist in British Columbia, for example. It will be coming into place in Canada. But all of these things, I think, create greater expectations on the part of individual citizens globally. And I think this is going to, as I say, step up the game for regulators and for legislators, thinking how are we going to sort of keep up with the advances and we think progressive changes in privacy.
And Michael reminds me of a good point, which is the question of consent. In the Australian law, you don't need to request explicit consent for the general collection of personal information unless you're collecting sensitive information. So it's more a notice base for general personal information, only a consent-based model when it comes to sensitive information. So there will be another issue to deal with there.
We've got a question here. Just before I get to your question, though, something just occurs to me that we should knock off now is when you have a requirement and a legislation like this that is that substantial, then you get to the reality of feet on the ground and boots and compliance and the ability for regulators to then go out, investigate, establish fault, levy penalties and the like. I mean, let's be realistic here. Does Canada, does Australia, does the EU actually have all that in place?
One of the major tasks for all the data protection authorities around Europe at the moment is to gear up the resources to deal with the GDPR.
Yeah, it's going to be massive.
It's massive. We're looking to increase our staff by about 15%, something like that. We've got recruiting 70 individuals. We've got 400 at the moment. So yeah, it's a big deal, and there are some massive challenges for some small data protection authorities who've only got 3 people working for them.
Yeah.
Regulators are always looking to keep up, and for example, I suspect in British Columbia we will get mandatory breach notification. We would have to get concurrent with that additional resources.
There's just no other way. Otherwise it's meaningless.
I was going to say, from our perspective, it'll be interesting to see what the expectation will be from our colleagues in Europe if there is an investigation that needs to be taken on in Australia. Will they be seeking to exercise their extraterritoriality powers and try to pursue the company themselves, or will they be looking for assistance from us to help undertake the investigation?
And would we be able to offer the assistance?
Well, that'll become a question then around law about, for example, I can't enforce European law. That's common sense. There could be, as we already do globally, exercise some joint investigation activities, particularly where there is an overlap in our laws. So we can help out there where there is a similar provision or a similar power.
Okay. That will be good news. I was going to say to all private sector folks here that regulators around the world, and that's part of what we've been doing with the Asia Pacific privacy authorities, we are working more frequently together and looking to ways to collaborate in terms of enforcement investigations. Well,
and we'll certainly make it easier for those organisations rather than having to do with 2 or 3. Where's our... Here we go. Hi.
Yeah. Hi, everybody. I'm Guy Cartwright from Commonwealth Bank of Australia. Is that loud enough? Or?
Yes.
Just wondering whether there was any particular rationale, whether you had any thoughts on the 30-day mandatory breach notification period here, as opposed to, I think it's 72 hours in the EU and in the UK, and just maybe potential difficulties in meeting the 72 hours, and why it is that there's a big disconnect there, I guess.
Yeah, it's a very big difference, and those who work in the security and critical infrastructure area would be thinking 72 hours sounds a little more healthy for them. But let's start off with you, if we can, Simon.
Well, we're preparing, a team to deal with these reports of breaches in that time frame. But I think we're going to, like so many things in the UK, we're going to adopt a pragmatic approach. We're not expecting people to be able to give us full details of the breach in 72 hours. It isn't going to be possible. What we're looking for is...
In some cases it might be.
Well, not expecting it to be possible.
Yeah.
In some cases it might be essential.
Yeah.
Because in some cases, in less than 24 hours, you might need to take a decision about whether to notify customers of the breach, and it may even be less than that.
Absolutely.
But I think we're expecting 20,000 of these, and of that 20,000, only a small proportion will require that immediate response. Whereas others, for people to notify us that there's a breach, that we're working out what's happened, it would be enough for us. Because it's not unknown for someone to think there's been a breach, but it isn't actually. And to then, if the requirement is within 72 hours to notify thousands of people of a breach that never actually happened, it causes more harm than good. So proportionate approach, quick if it needs to be, but longer if required.
Michael?
Well, this is not an issue we've had to deal with just yet, and we watched with interest the debate that went on in Europe of, within a reasonable time. And then I think that the thinking was, no, you have to put some certainty around it, and to a certain extent it's arbitrary, but important the line is drawn.
But given that it's not mandatory at the moment in Canada, why is that thinking?
That's a good question, and one we ask our legislators, and we actually then point out to them what's happening in the rest of the world, in Australia and Europe.
No one wants to hack Canada?
Certainly there are all kinds of things. Well, I'm thinking of Ashley Madison and other things, which were proudly Canadian company, I would add. Sure.
I stand corrected.
We're well versed with them now.
The federal authority in Canada that the data breach is happening. I think in British Columbia it's going to go that way. It is the way of the world, absolutely. I mean, individuals have a right to know if their data has been breached and to take measures to deal with that.
Well, it took 3 years, 3 attempts in Australia to get it through.
Yeah, really, yeah.
So in terms of
the time difference,
question, the time difference, well, I can always throw my hands in the air and say, well, that was the decision of the Parliament to allow the 30 period.
Yeah, but what do you think? What would you like?
Well, what I expect will happen is very similar to what Simon was saying, that a decision can be made very quickly that there has been a breach, and we would expect that decision to be made, particularly in the case of serious and obvious breaches, and notification to occur before the 30 days. But there will be some matters that will need to drag through or to be assessed to make sure there has been a breach. But it would be, any organisation would be foolhardy to suddenly try and not let someone know about a serious breach if they knew it immediately, because it will be a PR disaster for them, if I can.
Well, that's why I want to come back to the question, if I can. I mean, surely an organisation like the Commonwealth Bank, it's in your interest to contact the authorities within moments of this going on, yeah?
Of course, absolutely.
Yeah.
No one's going to Nobody does that. Nobody does that.
We know where you are.
That's right. With regulators sitting in the room. The only good answer.
You're a great representative for your company. Well done. Your bosses are listening. Did we have one over here, did we? No? Anyone else at this point? Okay, look, I want to go back to this. Sorry, who am I missing? Yes, sorry. Go right ahead.
Moira Patterson from Monash University.
Yes.
I just wanted to, one of the interesting differences in the GDPR is the provisions relating to automated decision making, particularly Article 22, the right not to be subject to automated decision making that significantly affects an individual. I was just wondering if any of the panel wanted to comment on that.
Simon, are you in a position to comment? I guess it's an extension, isn't it, of the expanded rights for individuals under this legislation?
It is, and it's an extension of an existing right as well to get an organisation to stop processing your data in the UK in certain circumstances. But I think that's going to be a challenge for us, and I think it's going to be a challenge for organisations. I think, as with all the provisions of the GDPR, there are all sorts of caveats and qualifications over when it applies. Yeah. So it's hard to know how often this will be an issue for the regulator in practice in the future. But I think it is definitely an area that's of concern for us, how to apply it and how the detail around it we have yet to bottom out.
But with the AI and the machine learning that you were talking about earlier, isn't it in some cases going to be hard even for the organisation to know in some cases whether this is going on?
This is an issue in British Columbia, particularly in the public sector, where government wants to link data.
Yeah.
So it might be to cut off somebody's benefits, for example, because you're declaring income here which was not known, and so on. And what we're working with government on that is to say you can do that by a machine process, but if you're going to disentitle somebody or in some way be prejudicing on an individual, a human being has to look at that before any decision is made.
It's an issue that's been very timely here at the moment in regard to our social security. I think think that's why the
as the room mutters to itself.
Yes. We've had.
I didn't get the briefing note beforehand.
Sorry. We've had a matter here with Centrelink.
Absolutely. Yeah, but you can't pin that on the machines. There was people making those decisions.
Yeah.
Well, it was also looking at the machines that were doing some of the algorithms behind it to determine benefits or not.
Yeah.
It was the quality of the data that was going in is in question.
Sure, but there was a policy position taken first, which is made by a bunch of bureaucrats.
Far more effective than machines, certainly.
That's right.
I just want to spend a little bit of time going through that, some of the key aspects of the GDPR as they affect or aim not to adversely affect individuals, the expanded rights for individuals you mentioned there, Simon, including the right to erasure, encompassing the right to be forgotten, the right to data portability, we had a question about that earlier, and the right to restricted processing. So in your estimation, and I'll get the other panellists to comment on this as well, they're significantly expanded rights, are they, Simon?
Yes, they are significantly expanded rights. The right to data portability is definitely an expanded right and intended to allow people to simply take their data and move it somewhere else. Where it's got challenging, I think, perhaps relates to a question from earlier on. I think it started off with just being data that you'd provided to the organisation, but now there's this worry that it could be argued it extends beyond that. Yep. That makes it more complicated for organisations to understand what the information is they're going to be transferring. There are challenges around this format of the data. It says I think it says machine readable, is that right, format? Yes. So we're back to the machines again, but those are challenges for you, I think. And there will be challenges for industry in the UK, and our problem as a regulator is, I suspect there'll be organisations who'll be doing their very best to comply with the request, but falling down on the job because it's very hard. And we've had conversations with some of the big players, including Microsoft, who this is a challenge for them, even with their technological expertise.
Was there much pushback from the private sector during the lengthy legislation and discussion period on this?
I think there was some pushback. I think this is one of those situations...
Hence the length of the discussion.
Well, this is one of those situations where the idea is great, but in practice it poses challenges. I mean, who could argue with the fact that you should be able to take your data that people are holding on your back and transfer it on?
I was going to say, these heightened rights are a big issue for the transference of data internationally because it's made easier where a country has a status called adequacy.
Yeah.
So if you're an adequate, New Zealand, for example, Canada is apparently an adequate country, if I can say that. But what it does do is that designation allows the data to flow, European citizens' data to flow to these countries. It's somewhat effortlessly. And so the question is, what will be adequate now in the future, given these heightened requirements? The right to be forgotten is a good example. In North America, that's going to be a harder fit because there are constitutional rights to freedom of expression, for example. So how does the right to be forgotten square with that? A lot of people have argued it can't, it won't. Right. And therefore, that's not a right that's likely to find its way into Canadian law.
I was going to make a bad joke and say it's terrible going to the meetings in Europe and being constantly told that I'm not adequate. I used to have an earlier response to that, but I won't mention it in public here. And I don't know whether it's more galling that our good friends and colleagues across the ditch in New Zealand are adequate. So anyway, I'd like to jump back, though, to the question of data portability because it's actually something we're going to be grappling with here very, very quickly because the Productivity Commission brought out a major report into data use and getting more data out, etc., etc. And one of the things they referred to was the introduction of what, I'll be careful with my words here, what they termed a new consumer right. I would argue, and I will argue quite vehemently, that the rights they're referring to already exist in the Privacy Act. But one of the things they talked about was data portability,
right.
And introducing that as part of a new scheme. So we would say that the Privacy Act can already provide for that because it says a person has the right to access their information in the form in which they request it. So we're some way down that path.
And has that been endlessly debated, discussed and argued with?
Which aspect?
Well, the introduction of that requirement.
Well, that requirement has been in the Act for quite a long time, for access to information and providing it to people. Businesses have been complying with that since they've had to comply with our Act. What may be necessary from an Australian perspective, and sorry to go off on a tangent here, will be a little bit more specificity if we're to do it under the Privacy Act about what the term of portability will mean. But it's possible, and we could do it in the same way to meet the requirements of the GDPR.
Should we just bring in a brief discussion here, Simon, this does fall to you, about Brexit and the consequence of that? Well, it's a reality. And you're going to have to talk to it today. Well, I mean,
I love talking about Brexit.
will everything that's expected now under the GDPR, will the UK be excluded from that?
Well, not in the short term, because the GDPR comes into force at the end of May next year. The UK, unless something incredible happens, which wouldn't be the first time, will still be in the EU then. So the law becomes force. It's sort of in force now. This is just a 2-year period until it comes. And so we will be applying the GDPR. In the meantime, we're preparing for the future. And that means in the UK we're developing a new Data Protection Act, which will incorporate the GDPR, which will incorporate other stuff around a directive that relates to law enforcement agencies, and will also incorporate some criminal offences that we have in the UK for people who blag information by pretending to be someone, or so those will all be pulled together, and then when we do leave the EU, depending on which form of leaving, which form the leaving takes place.
Soft, hard. What's it going to be, Simon?
Medium rare, I think. We can't be sure about what will happen, but I think we can be pretty certain that a lot of the provisions of the GDPR cannot apply because we won't be a member state. So we can't be a lead authority. We can't deal with complaints in France. Not that we'd ever really want to, but we can't anyway. They can't deal with complaints about us, which is more important, I think. And we wouldn't be able to use the European Data Protection Board, which is going to be the oversight board for all the member state data protection authorities. So that's all out for us. I'm in the interesting position of I'm adequate now, or the UK is, but we'll be inadequate in a year's time. Oh, sorry, when we do leave the EU.
You'll be in good company.
So we'll have to work, and there's a lot of work in the UK going into how we continue to allow data flows to be uninterrupted. That's a big priority for the UK government, very big priority.
Simon, you spent a bit of time in your previous paper speaking about consent and how important that is. But I just want to ask Timothy and also Michael about this. Consent under the GDPR must be, and you mentioned before, freely given, specific, informed and unambiguous. So what does obtaining consent look like where these requirements are met, given that, I mean, we can talk about the GDPR context, but let's talk about it from an Australian context. Is that wildly different from the requirements here?
It's not wildly different in the context of sensitive information, as I said earlier.
Only
That's where sensitive information requires consent.
How's that defined?
You need to give notice. Sensitive information, people's sexual preferences, practices, whether they're a member of a trade union, some other sort of association. Health information is sensitive information. So we look at those. There's a lot more to it, but they're some of the key ones, for example. So if you're collecting that, you have to get consent in the same form, basically, that the GDPR is suggesting you do.
Okay.
So if you go into an organisation and you want to, you're asked for your driver's license, not driver's license, it's a bad example, say your address or something, you need to be given a notice about why that's being collected rather than being asked explicitly, will you give it to us? So it's a very difficult concept. It's one that is really under a lot of pressure globally, generally, about whether people can actually give freely given consent in different circumstances. For example, when you're dealing with governments, You are required, if you want a benefit, to provide information. And if you don't provide that information, in a lot of cases, you won't get that benefit. So where does consent
and same in the commercial context.
It is indeed. And I'm thinking, if you want to be on a social platform with your friends, you go to some obscure platform, you've got no friends there. So if you want to engage, realistically, I mean, people are going to go to Facebook, and there is clearly a power imbalance. And actually of interest to people here is a recent Supreme Court of Canada decision, I think it was just last week on this topic. Somebody complained because they ticked a box that they liked something. And the next thing they knew, their image was being used to advertise that product to their friends. Not something that Facebook does now, but at the time they did. The person complained. Facebook's response was, you remember that agreement you signed? Any grievance you have with that, you need to go to California to prosecute the case. Supreme Court of Canada decided just last week that in fact was really unfair. It was an imbalance of power, and the courts of British Columbia, where the person lived, was entitled to have redress there. So between the courts and the regulators, there is some attempt, I think, to redress some of the power imbalances, because you're right, sometimes the choice really effectively isn't there for the individual.
Do we have any other questions? We've just got a few minutes left of our conversation before we break for lunch, and so it's a good opportunity to get some concrete answers from the experts here about what the GDPR might mean for you. No, not at this stage. Yeah, we've got just one here, sorry. Malcolm, hello.
Malcolm Crompton from Information Integrity Solutions again. GDPR, cross-border privacy rules and the APEC, binding corporate rules in GDPR and the APEC cross-border privacy rule system. How will they interact in the future, and how will work be put into bringing those processes together rather than pulling them apart? APEC and EU Article 29 Working Party are already doing slow work on that reconciliation, but really, is it going to accelerate or is it going to stall?
I guess...
second question, will Canada be adequate in the future now that there's a GDPR?
You want to try? Yeah.
Well,
and then we'll come to Timothy as well.
I assume everybody knows what he means by BCRs, because that's a European thing. They're binding corporate rules where a big company who's got operations in different member states sort of comes to someone like the ICO to approve a scheme for transferring data around. Broadly speaking, Malcolm, I hope that's okay. We're very concerned about this in the UK, because when we leave, any companies that are in the UK won't be in the EU, so the binding corporate rule approach will be in doubt. And so we're very interested in the more global approach of the cross-border privacy rules, which is a similar thing, but applies to countries anywhere. So we're certainly going to be pushing as hard as we can to come up with some form of mechanism for facilitating this globally in the future. How well we'll do, I don't know, but that's definitely something that's going to be on the government's agenda in the UK. We think it's a big deal. It doesn't cover everything, but it does cover a lot, and it will help UK business, we think, given the changes that leaving the EU brings.
I think the only specificity I could say around that is, I think, Malcolm, you sort of alluded to it, which is the speed with which it's happening or not happening at the moment, and I think the GDPR is just going to add complexity to that and potentially slow down that process, so I really don't have any more to add than that.
And I guess sorry, go on.
Oh no, I thought there was a follow-up question about Canada, which I wasn't
going to let go. Canada's adequacy.
I'm not going to let go of that adequacy. Sure.
We will not let the Australians speak for us on that part. Well, we don't know, but one of the interesting questions around this, and we watch the Commission now struggling with what is, a European Commission struggling with what is adequacy. The whole Edward Snowden issue, national security, Europeans' data getting caught up in Canada, for example, the same questions that were raised about the United States and how the United States was treating European citizens' data when it was swept up in dragnets and so on, are going to be raised in Canada, because we're part of the Five Eyes between Australia, New Zealand, and so on. So this is going to be a big challenge. In the US now, they at least have the Judicial Redress Act. Canada, we don't have any similar thing, which would allow a European citizen in the United States to have some sort of a mechanism to complain. Doesn't happen in Canada. That's just one factor in many the Europeans are going to look at to whether we are judged adequate.
And Simon, you wanted to jump in?
Well, no, if it's finished, I was just going to say I have a question for the audience if there are no more questions, but I'll leave that up to you, Chair.
There are no more questions. What is your question for the audience?
Well, how worried are you about the GDPR and its impact on your business? Maybe you should do I'm terrified through to I don't care.
Starting with I'm terrified, show of hands. Moving down to meh. And does not apply? Hands up. Oh, well, a lot of you just didn't vote in that one, so that's why we have compulsory voting in this country. What do you deduce from that, Simon?
The Australians are apathetic.
We try.
We're chilled. We're chilled.
You know, in truth, you know, the larger companies are obviously taking this issue on now. It's really, I think, in many ways, it's the small and medium-sized enterprises that might, you know, it's a flower shop in Sydney who takes orders from Irish and French
people. They fall under the exemption.
Oh, they do. Well, in Canada, they don't. They wouldn't. But
yeah, but come on, no one's going to fly it from Europe and try and hit the small.
We hope
floor.
not.
Oh, I don't know.
They're not going to have time.
You don't know the French, I think.
And we used to say
we're getting into old fights now. We're getting into old fights. And I think at that point we might just leave it there. Would you please thank our panellists? Timothy and Michael and Simon, thank you. Thanks, everyone.